Okay, so today I welcome you all to the and the topic of our discussion is representation of trans community in higher judiciary. And we have with us Vedant, who is also a law student. And before we proceed further in this topic, I would like to just discuss about the term transgender, what it means. Like transgender term is basically used for people whose gender identity is different from the sex which was assigned to them at the time of birth. And it has been used as an umbrella term for those individuals who are identified as transsexual or person having no gender or multiple genders. So in India, during the first regional consultation on transgender and hijra issues, which was supported by UNDP in 2009, the transgender, they were also defined as an umbrella term for both Western precedent and also the distinctive Indian as well as the South Asian reality of many communities and the identities of people who were marginalized for their gender expression or their identity, which is including but not limited to the well known Hijra community, which is a socio religious group of feminine identified people assigned male or intersex at birth. So when we talk about the discrimination based on homosexuality or the transgender status, necessarily it entails the discrimination which is based on sex. So the first cannot happen without the second. Transgender, they still live a life of discrimination and complication in the society. So shouldn't they get treated equally? To date, this community is seen as a threat and they are being outcast by the society. So, being one of the pillars of the society, the judiciary must make the inclusivity of the norm so that we will have a visible and dynamic impact on the society as a whole. So now I would like Vedant to talk about the landmark judgments which talk about the trans community representation as well as their rights. So
Thank you, Anupama, for your introduction. Now we will move on to the evolution of the rights which were not given to the trans community initially. And then there were various landmark judgments by the Honorable Supreme Court, and they recognized these fundamental basic human rights which were already guaranteed by the Constitution, but it took time to get the rights recognized. So on this note, I will share my screen. I hope my screen is visible.
yeah, it's feasible.
So our today's topic is representation of trans community in judiciary, in higher judiciary. This is the code, but we'll deal with this code in latter part of our discussion. So what exactly is the matter here? Just a second. Yeah. So the battle of equality and recognition and citizenship for queer bodies has been a long and and is still ongoing. These community is not getting the fundamental right which they are guaranteed by the Constitution itself, and they had to fight a lot to get recognition as a citizen also. So it is very unfortunate that a great country like India unfortunately had to struggle so much years and years to get this recognition. But our judiciary, and it is important to note here that our parliament has not shown a keen interest in dealing with this issue. We can say the inherent narrow-minded mindset which our parliamentarians carry, or we can say the lack of awareness or the lack of knowledge which these parliamentarians had. But yes, there were few people who had tabled the bill for the transgender community. I remember Dr. Shashi Tharoor had tabled a bill regarding this, but unfortunately it lapsed. So, but here our judiciary came to protect our transgenders. And the very first case was the NAS Foundation case. It is popularly known as the NAS judgment of 2009. The NAS Foundation versus the government of NCT, that is Delhi, National Capital. So in this, NAS Foundation was the non-governmental organization based in Delhi, which had filed a public interest litigation, that is PIL, at Delhi High Court, and they had challenged the constitutionality of the Section 377 of the Indian Penal Code. And interestingly, the Delhi High Court gave a very progressive judgment in this case, and they said that Section 377 was unconstitutional, which violates Article 14, that is equality before law and equal protection of law, Article 15, that is prohibition of discrimination on the grounds of race, caste, sex, sex, and Article 16 of the Indian Constitution. And this judgment is considered to be a very progressive judgment. Now, if we consider the NALSA judgment of 2014, so the year 2013 was a very dark year, some people say, or the darkest period of the trans community, or in general also. So in this period, the Suresh Kaushal versus Union of India judgment was given, and here homosexuality was recriminalized. If we go back again in this judgment, NAS Foundation, Anupama, here the Honorable Delhi High Court had decriminalized it, but in 2013, the Suresh Kaushal judgment recriminalized it. So this was a very outrageous movement in entire country. People were protesting against this, but this was for a very short period of time until the 2014 NALSA judgment came. It is a very famous judgment of National Legal Services Authority versus the Union of India, which was delivered by the Honorable Supreme Court. Here, for the first time, like, we should say it's very good, but we should also then feel that it is unfortunate that in 2014, for the first time in the history, transgender people were recognized as a citizen of the country, and all the fundamental rights of our great constitution were extended to them, and they were given the identity of third gender. Now, if we consider, India got independence in 1947. Supreme Court of India was formed in 1950, and it took so many years to just get a recognition to be a citizen of this great country till 2014. But yes, this was a very progressive judgment and very celebrated judgment, because for the first time, trans community was recognized under Constitution. Now, if we go to case Puttaswamy judgment, this judgment is technically very important. If you consider, you might be knowing this is a very famous judgment for right to privacy, right? So in this case Puttaswamy versus Union of India, or Puttaswamy judgment, it is popularly known, or it is also known as the privacy judgment. Here, the Honorable Supreme Court had recognized that the right to privacy is an integral part of the fundamental right of Article 21. So Article 21, what does Article 21 say? Article 21 says right to personal life and liberty, it guarantees it, right? So Supreme Court extended right to privacy also in Article 21. So now, and interestingly, because the next judgment and this judgment are very important, because the judge who had delivered this judgment is very important. This judgment was written by Dr. Justice D.Y. Chandrachud, and he said that the right to privacy was also extended to the gender and sex, and recognition of privacy for members of LGBTQA community as an inalienable grants them autonomy and protection. So, right to gender recognition was in or within right to privacy. If we understand the correlation, why this judgment is important, because here right to choose a gender was under right to privacy. As right to privacy was a fundamental right, then automatically right to choose the gender is also fundamental right. Right. Now, if we go for the next judgment, it is very important, the Navtej Singh Johar. Now, if we consider, the Supreme Court had the precedents of Nalsa judgment, which recognized the trans community, the case Putta Swamy judgment, which gave the right to privacy and also the right to gender recognition as a privacy. Okay. In 2018, Navtej Singh Johar case happened, and again here Dr. Justice D.Y. Chandrachud was on the bench, and I think it was a 5-judge bench, but primarily it was written by Dr. D.Y. Chandrachud. So in this case, the section 377 was decriminalized. So the story which had started in 2009, if the viewers recall, I had mentioned the Nas Foundation judgment of 2009 when the Honorable Delhi High Court had decriminalized it, and again it was recriminalized in Suresh Kaushal, and then in 2018 in Navtej Singh Johar, section 377 was decriminalized, and the Honorable Court said that section 377 violates Article 14, 15, 16 and 19(1)(a). So 14 we know that is equality before law and equal protection of law. Article 15 says that prohibition of discrimination on the grounds of race, caste, sex, religion, place of birth. Article 16 says equal opportunity in employment, public employment. And Article 19(1)(a) is very crucial here, because Article 19(1)(a), Anupama, says the right freedom of speech and expression. It grants every citizen of India the freedom of speech and expression. So what will be my gender is my freedom of speech and expression. And section 377, according to court, was violating this fundamental right. So this is very important. And yes, after this judgment, this was a very celebrated judgment, and finally the legal battle of trans community, their rights, their fundamental rights, their basic human rights, their recognition was observed. But if we consider these 5 pillars, the 5 judgment, we can say, are very crucial. After analyzing all the judgments, this gave the recognition rights. They were officially recognized as a citizens. But now the question arises, after delivering all these judgments and after doing all these things, but a question arises, what about the representation? This is the biggest question of trans community, because it was a, I should say, and I dare to say that it was a joke when in Parliament the transgender protection bill was passed, and not a single person in the Parliament was representing that community. So we can say this is a mockery of the system, because if the person for whom you are making the law is only not representing, so here we should introspect, and here we should discuss that how we should increase the representation of trans community in all the institutions, including our great judiciary. Now, if we consider the next case, so here there is one controversy, I can say, since 2017, where Advocate Karipal was recommended since 2017, but still you can see on the screen March 2021, till now Advocate Karipal has not been appointed in the High Court. So here we can say that our the government is having some prejudice, the government is having some regressive thinking, we can say, or we should say that there is another thinking which is leaning towards the society, what society thinks that the government will think.
Yeah, it was the fourth time that his name was rejected from
Yes.
the recommendation list. And I just want to interrupt you there. And the bill that you mentioned, actually the act that you mentioned, the Transgender Person Protection of Rights Act 2019. So, there was a provision that made it difficult for the transgender people, that they had to get the identification. They have to submit the documentation that will show that, yeah, they belong to that gender. So the recognition of their identity can only be approved by a district magistrate as per the provision of the act. So many transgender people, they do not have the proper resources, so it became very difficult for them to get their own identity. So this was challenging for their culture, and it was really difficult for them to like show, yeah, I belong to this community. And the same, when we talk about the representation, in 2017, the first transgender person who was appointed as a judge in a lok adalat, she was Jyoti Mondal. And then in 2018 there was Satyashri Sharmila, who became the country's first transgender woman lawyer. So the representation is very less when we see in the judiciary. And the legal profession is said to be open to all people from all the strata of the society. And a career in law is basically an ideal platform for the marginalized section to basically break into an affluent segment and help the similarly placed people. So it is often argued that the judiciary, being the embodiment of justice, is it basically falls behind in being proactive to include the members of this trans community within its structure. And the same can be evidenced through the lack of representation in the judiciary, especially considering the instances like the failure to elevate the Saurabh Kirpal, who was an openly gay senior advocate as a High Court judge. Despite the recommendation of the Delhi High Court, he was recommended for elevation in 2017, and the proposal was endorsed by the top courts collegium too, but it was deferred. And one of the reasons which was cited was regarding his partner. So here we can say that Kirpal faces dual discrimination at the hand of the center. First is because of his sexual orientation, which was a gay person, and second on the ground that his partner was a foreign national. He was basically a Swiss human rights activist, and it is hard to see how these two grounds, independently or together, could pass Article 15.1, which talks about the prohibition on the discrimination. So we can say that surely the center needs to follow some consistency, which is based on convincing reasoning when it comes to deciding like who should be our judges, rather than just given into prejudice or xenophobia, right? So even in his book that you have also mentioned in the slide, that is Sex and the Supreme Court, basically Kirpal talks about the issues relating to law, gender, and the sexuality. This book basically concerns various decisions of the Supreme Court relating to sex, like sexual workplace harassment, adultery, or 377 judgment, or the Sabrimala judgment, or the triple talaq judgment. So uh, yeah, if we talk about the diversity and inclusivity in the judiciary, we can say that society is the product of the people who live it in. And unfortunately, the India's colonial past and strong tradition of caste and patriarchy, they have the most of the influential decision maker almost from the upper caste, right? So what are your views on this?
Yeah. So as I said, that there was one write up. I would again like to share my screen for that purpose. I hope my screen is visible.
Yeah, it's visible.
So this was the quote, that a diverse judiciary not highlights the equal representative character of justice delivery mechanism, but also can lead to creative solutions to problems by utilizing the diverse human resources. This was a great quote which I found while researching about this topic. So basically, this quote is trying to say that we celebrate India as unity in diversity, right? But if the great institution of judiciary, the Supreme Court, the High Court, the lower judiciary. The Supreme Court is the guardian of our fundamental rights. So all these institutions, if are not diverse, and if are they are only confined to one community or one specific gender, so the creativity will lack, which the author is trying to say. Now, if suppose, if we take example, suppose there is one transgender judge, definitely the creativity will increase. That transgender will definitely think something which we cannot think, or we might not think, right? And if we see the data also about the representation of other communities, there the news is not very good. Like currently till now, there is only at present there is only one SC judge. So in the entire Supreme Court, there is only one SC judge. Then women representation is, yes, day by day increasing, but it's negligible. We should accept it that it is negligible, because in the entire judiciary, as of my knowledge, as per right now, there is only one female justice, that is Justice Indra Banerjee, if I'm correct. And I think there
Yes.
is one, yeah, and our collegium has right now recommended some nine judges, out of which I think some four are females. So it's a good sign there. I may be wrong with their number out of nine.
No, actually, it's three. It's three, I guess.
Okay, yeah. So then also it's good, right?
Yeah.
Out of nine, we are progressing. Out of nine, three are female.
Yeah, yeah.
So the basic point is the judiciary should not be a monopoly of one community, whether it be a monopoly of a gender, monopoly of a caste, monopoly of a religion, monopoly of a region, monopoly of a high court, because we sometimes see that in a one particular high court only they are elevated to the higher judiciary. So the judiciary should not be a monopoly, it should be a diversified institution which represents the entire diversified India, which is very important. And hence the creativity increases, and we get good judgments. So what is your opinion? Like, this is my conclusion, that the diversity in judiciary should increase.
Yes, I agree with you. Like, merit has to be judged on the, yardstick of opportunity. Like, India needs more trans participation in law, especially as an advocate, because they understand the language and the complexity of the issues which is faced by their own community. So when there is a direct participation of the community member, they can provide avenues to interact and correspond with the law functionaries without any fear of harassment or violence. So if I would like to suggest what I think the changes must be there is sensitization of the judges, lawyers, and other law and justice functionary is very necessary to make this profession more inclusive and to corresponds to how the legal institution needs to open up to different identities and create a non-discriminatory and non-judgmental space for everyone. And uh, like it is very imperative to have the diversity at that level, so that the decisions that are not made by men who are sitting in ivory towers and who are immune from any struggle of the society that they live in, like it must also include the people who belong to the marginalized society too. So that's all I would like to say in my conclusion.
I would like to add one more point here. I was just about to read this article. So the data says that only 80 of 1,113 judges in High Court and Supreme Court as of December 2020 are female, are women. So we can see the proportion is grossly unequal.
Yeah, we have also done a podcast on the women representation where we have discussed all these points. Roughly there are only 11% of the judges in India who are
Hmm.
women, and we have also talked that why, if you see, even if you see in your class, you will find almost 50-50 ratio of male and female who are enrolled for undergraduate program of law.
Undergraduate track.
But not many women lawyers, they get elevated to senior position, and what's the reason? Like, if they are there with you in the class, then what's the reason behind that, that they are not
Yes.
reaching to the position where the other male members are? So this gender disparity can somehow be like connected to the uh, patriarchal patriarchal thinking of the society. The people who are in position of power, they are also product of society, and they must reflect the society's belief in a very positive way. And somehow we cannot rule out the possibility of the inherent patriarchal conditioning. And somehow even today the males are somehow they feel like inferior if a woman is senior to them. So these are, you are on mute, Vedant. Like, if you are saying
Yeah, yeah.
something.
No, I was about to tell one more shocking data, which says that in 71 years since the Supreme Court was founded, the apex court has only one judge from the ST community. So this proportion is also very shocking, that only one judge since the formation of this institution in 1950 till today, there is only one ST judge. And if you consider right now also, Justice B.R. Gawai is the only one judge in Supreme Court who belongs to the SC community, scheduled caste. So that's what I was pointing out. This proportion should be equal, or should not, or we can say there should not be a monopoly over it. Monopoly of a gender or monopoly of anything is bad for such a great institution, which is protecting, or we can say officially a guardian of our fundamental rights.
Yeah, it's very true that affirmative actions must be there, taken by all the levels of the judiciary in order to deal with these issues. These are very sensitive topic, and sensitivity to such kind of discrimination must be cultivated. It cannot be corrected by a single action. It can only be done through many small steps like sensitizing, or giving trainings, or somehow like doing such programs that will change the mentality of the people. And this is high time that the system must look into it, so that there is a equal playing field for all the people who are part of it judiciary system.
Yeah, I would like to add a point here, as you said, making awareness and all. So I give the task to our viewers also. Just randomly ask, what does LGBTQI mean, or what does LGBTQI plus means? It is unfortunate that no one will know. I bet there will be one person who will know the full form, but who will know what exactly is that. So making people aware, our politicians, I don't think so our politicians will know, exceptional like Shashi Tharoor and all. They are very sensitive over these topics, and they have tabled time and again such bills, but unfortunately our parliament has lapsed it. And saying that this is not, I would like to say that when Shashi Tharoor had tabled the bill, uh, like striking down the section 377 to overturn the Suresh Kaushal judgment, I guess, yes. So that time the government had said that this is against our culture, our morality. So such people are in our parliament. Okay, we respect them, but then the person who is also from the community should also be there in the parliament. So at least there should be affirmative action made for. I think the Karnataka government has introduced affirmative action for the transgender community in their policy. And this policy also should extend to the national level and to other regional institutions. Uh, Viewers, there is some problem here, network problem which I'm getting. Let's see if we are able to solve it.
We can
Hello.
hear you. You can continue with your Vedat, we can hear you.
Yeah, so there was some network issue. That's why I think Anupama has left and she is unable to join.
Okay, you can till what time we have covered? We can continue with the subject.
So we were about to conclude the topic of representation of trans community.
All right, all right. What was the conclusion?
So the conclusion was as we say that India is a diversified country, and we celebrate that unity in diversity. So the great institutions like judiciary shall also represent that diversity, and that diversity will lead to creativity, and then which will in turn lead to creative laws or creative interpretation of the laws, which is very essential. So this was our conclusion made, and at the last, what we have said that like Karnataka government, I guess they have made the affirmative action policy for the trans community. The central government should also work upon it, and also our other institutions should work upon it, because it was, we can say, a joke where the transgender protection bill was passed in the parliament when not a single transgender person was representing the community, and we were making a law for that community. So this is unfortunate.
So, would you like to suggest
I
some
have
change?
one question.
Okay.
Okay, I want to put one question. Why do you think this collegium should go ahead with having representation from the sections of they should put a diverse representation? Why judiciary should consider it?
Yeah, so collegium should consider the diversity also, because any institution cannot be a monopoly, and especially when it is a great guardian of fundamental rights, it should not be a monopoly of a particular gender, particular caste, religion, or region. It should represent the diversity of India. So that's why the notion of diversity should also be taken into consideration. And if we consider the example of senior advocate Karipal, who was recommended in 2017, was a transgender, was recommended by the collegium, but it's 2021, still the government hasn't approved. So here we can say that lack of political will, or uh, the inherent lack of awareness, or the inclination towards what society is thinking, that this is not moral, or we don't accept it. So this is the case.
Okay, but since judiciary is a very expertise, requires a high level of expertise, so we cannot ensure that diversity. There can't be an insurance that diversity would be represented. So there we can assume it could have a diversity that is inadequate. So that's a fine thing. Can we agree on this?
Yeah, as you said, merit should be considered, and in the farewell speech, Justice Nariman also said in his farewell speech couple of days ago that merit should be considered always while appointing the judges. Yes, So,
So there
do
is a
we?
conflict thing, like we have to balance diversity and merit. Because
Yeah, so we need to balance it. And now, if we consider the collegium had recommended, right? Senior advocate Karipal was recommended by the collegium. But then, what is stopping the government from approving that name since 2017? And it's 2021 now. There is no reason. And the senior advocate is openly saying because of my sexual orientation.
Yeah,
So,
sexual orientation and his choice of partner. His partner was also foreign national. So yeah, it was in controversy that this is against the right which are given under Article 14 and 15. And adding to your points, I would also like to say that why this is necessary is because when a person from the same community, is there, especially as an advocate or as a judge, they will understand the language and what are the complexity of the issues which is faced by the community to which he belongs. And when there is direct participation, it will provide the avenue to interact and correspond without any fear or without any suppression from the people who are in power. So this is very necessary that we get equal opportunity, and this does not just apply to the trans community, it also applies to women representation as well as the people who belong to lower caste too. So you are on mute, Vedant.
yeah, I was not speaking. You may continue. I think we have
Okay.
covered
Yeah,
mostly all the points.
yeah,
So I think we can then end the podcast.
yeah. Okay, let's call it a day. Okay, thank you very much.
Thank you, viewers.